Good morning. Wanted to go over something because I'm working on one right now, and I think it can be helpful for people who can think through it and do it for themselves if they're self-representing. This happens to be in the arena of an overpayment case. Now, overpayment cases are fairly cut and dried if you have the evidence. It's not highly discretionary if you have really objective evidence, right? You either made too much or you didn't make too much, violating whatever rules you're under, whether it's SSI or SSD. So I find that if the individual, say, has W-2s or pay stubs that show a different work amount or a different hours worked amount, or they have receipts for impairment-related work expenses that could, depending on what number they're trying to say someone breached, it wouldn't be trial work period number because IRWEs, impairment-related work expenses, don't count. But for SGA, when that question comes up, they do count. So if someone, and I did this successfully in a recent, well, 2020, still going on, for other reasons, six-figure overpayment battle. If a person can locate, say, receipts that would, either be IRWEs, or if they are self-employed and need to bring down their income and have business-related expenses that they didn't write off on their tax return, so that they're, a lot of people, when they're small business, they don't realize all the things that are business expenses that could be written off. So they can present that, those receipts. And what I would suggest is the form called the SSA-795 is a fabulous, it's a certified kind of under oath statement. So you want everything in there. You don't want to have emotion in there. No opinion, emotion, blah, blah, blah. It's purely just objective facts. I am the claimant. Attached are my pay stubs. These accurately reflect the hours I worked and the gross wage information. That would be a W-2. Here are, and you could have multiple, if you want to keep them all, here's going to be about my pay stubs. Here's going to be about my income-related work expenses. Income-related work expenses would be receipts for co-pays that are permissible if they're related to the disability specialist usually, or medications. You could go to your pharmacy if you don't keep your receipts for your medications that help you get through the day and allowed you to do work in that particular month, or if it's a medication that lasts 3 months, it could be spread out. You can go to your pharmacy and ask for a printout from X date to X date. Usually I go back as far as you can. You may, it's better to have too much information than too little, but you're only going to point out what you're going to point out. And you say, here is the printout from CVS showing my prescription expenses for the various months. And this is what I paid out of pocket for my prescriptions. For September of 2023, I paid $75 for a 3-month supply of Percocets or whatever it is. That would have you then be able to spread the 75 prorated over 3 months. If that extra $20-something a month brings you under the SGA. But my point is this SSA-795 form. It's where you can explain, you can attach, I would label them, attachment 1, 2, 3, or however you want to do it. Attach them to your 795. Everything you refer to in that 75, you attach documentary-wise on the back of it, refer to it in attachment number and describe what it is and what it shows. Again, only facts. Nobody wants to be hearing, crying the blues and how badly you feel. That is not the purpose of this form. This is for you to get evidence in that the judge can take seriously. It is also something you can testify to at hearing, but it's helpful. Sometimes hearings are very short, very quick. If you already have it in as a 795, you submitted it and it's an exhibit, make sure it's an exhibit in your file at the time of hearing. It is now evidence that has to be considered. Does the judge have to believe it? No. But most likely, if there's not a reason not to, right, they're going to. I mean, when that CVS printout says it's your name on there, they're not necessarily going to disbelieve CVS printout. Why would they? So I think the 795 is underused, maybe. I do use it. I'm using it on another overpayment case. And I think it's going to be superb because it actually might clinch the whole matter. We're going to hearing on overpayments. Don't get too, if you know you weren't overpaid, like you know the rules and you've got your math and you've got your receipts and you know you were not overpaid. It might have been receipts that you did send to SSA, the field office, when they were, thinking maybe you had an overpayment. Sometimes these things don't get considered, well considered by the field office. So when you get it to a judge who has a little bit more, brain on, it can be a whole different ballgame. So I wouldn't necessarily give up if you know you've got these receipts that are yours. It could be this type of situation where the detailed earnings report, which I think is what the SSA goes on to find that someone, say, worked over SGA. And if you can prove that the detailed earning report does not reflect all the things you're allowed to deduct or is otherwise incorrect. I have a situation where it is incorrect. And that incorrection stand for occurred from a double reporting of one set of income. And what can happen is the employer reports an income or the payments made to an employee. I'm not sure how this goes down logistically, but apparently, claimants who are employees, and I assume this could be self-employed too, but it's outside of my pay lane. This occurs outside of generally when I represent somebody. So I don't see this occur. I just happen to know something occurred after the fact when the person came to me. The person went online because now you can be a diligent reporter of your working income, which the SSA says you're required to do. And it used to be we do it by phone, by letter. This does seem like a great way to do it. However, in this case, sometimes your employer is not the one that shows up as the payer of the payroll. It depends what companies are working together. Like payroll, they might have a payroll company. And in certain situations, like this particular one, the payor company reports it as if you're working for the payor company when actually you're employed by a totally different company. And this is all that little silliness with payroll. And so here we have a payroll company reporting X thousands of dollars for this person. When this person went in and reported their income, they report it as being paid by their employer because technically that's the pay stubs they get. So now the SSA is saying, oh, $10,000 coming from two different places. This person made $20,000 over SGA. And it was explained to the SSA, but at that time, of course, claimant nor attorney has access to a detailed earnings report because we don't get any of that stuff till we don't have access to much of the stuff until we request to go to hearing. Then eventually the hearing office gets it all together and puts it up and we have full access to that. So because the SSA has not gotten up to speed and given full access to all of this stuff, and I think it's wrong, it's an inefficiency. Had they done that, we could have pointed out exactly where they're getting their misinformation and here's the proper blah, blah, blah. But they didn't. So now we're, taking more time out of the system and going to hearing. But the 795 now will be used we can point out what the detailed earnings statement, and here is the documentation that proves that's incorrect. Now, that documentation was largely sent to the SSA before, but it was ignored because they were looking at this detailed earnings statement that we didn't have. So we couldn't say, hey, your detailed earnings statement is improper, and look at these numbers. See how they exactly show that it's improper? So the fact that you get more information when you go to hearing, unfortunately, you have to wait. Combined with this SSA 795, we're going to get this whole position in with evidence backing it up via the 795 way before hearing. Might it result in a on the record decision in our favor? It could, but don't ever feel like that's going to be the obvious, because that seems to be more the exception to the rule, and you're going to win later anyway. They just don't do a lot of OTRs. Might be a staffing thing, I don't know. But so the 795 is going to be there with all the attached documents, and the 795 is going to be the claimant's statement and that claimant's signature saying, this is the W-2 I got. This is the W-2 I got from them. Here's the letter from my employer saying, no, she did not work for both companies, just the one. That's our payroll company. I mean, all this stuff that we've accumulated, and that the lower level did not, adequately review or consider or inquire. They don't inquire, by the way. They'll just say, give us evidence. They won't say, like, well, do you have that? Like, whatever they think they need, they're not going to tell you what they need to change their decision. It's unfortunate. They just don't. They just go, repeat denial. They don't say what they think is missing, or, hey, do you think you have this? They just don't do it. So now we're here, and I'm thinking, hey, if we have this, and my claimant, has this. So that's going to go in now. OTR, on the record award or not, I always assume not. I always plan for the case going to the full end so that we always have our bases covered. When we get to hearing, now let's say a claimant is not a well-spoken person, gets very, very anxious, can't really explain it all very well, or maybe can. But if not, then there's going to be me saying, Judge, if you look at exhibit so-and-so, the claimant previously submitted a statement explaining all of this, along with the documents that support it. So there's no escaping the fact that the claimant made this statement under oath, even if the claimant can't well articulate it, because it is a numbers thing, and it can get a little confusing, but we have it all in writing. Claimant and I are going over that now to make sure what I have helped her draft up, and then I'm showing to her, and she can say, yes, that's correct, that's right. We'll go over the numbers and make sure everything jives, and then she can sign it if that's all correct. But either way, it's in before the hearing, and it will be testified to at the hearing. And if it cannot be due to nerves or anything else, we can direct to the attachment that explains it without nerves having to be implicated, and prevent the testimony because it's already been put in under oath. The SSA 795, I'll attach a copy below. I think it's a great document for getting in objective things like this, and testifying to, in a sense, under oath statement about this document is what I received, that she's claiming this is what I received. This is my W-2 I received. This is this, and I received it. And again, it could also be for business related work expenses if you're self-employed. Here is my cell phone bill that I did not put on my taxes, not being aware that I actually could or should. Here's a copy of my bill. I had a case where it was, we're fighting something from 15 years ago. The person didn't have all their cell phone bills, but we found one or two from 2008 stuck up in the attic. One can say, this is my July 2008 cell phone bill. This is representative of every bill I had every month for, between then and 2013. My bills were in this approximate area, or were exactly the same or whatever. And that would be a reasonable and expected response, because cell phone bills they do go on forever, kind of in the same amount, right? Or it could say, it was like this in 2007. I know it increased later. I don't have copies of the increases, but even if you use the lower amount, Judge, as the deductible amount, I'm still under SGA. You follow? So submitting that document and just saying, this is one of my bills. This is representative of the minimum it was for the next 10 years. It did go up, Judge, as I recall, but I do not have copies of those. But even if we use if we take this as being the floor of what the bill was. Anyway, okay, SSA 795. I know people with overpayments rarely can get an attorney or a non-attorney rep to go through it. That's because we don't get paid for it. And it is, in many cases, more labor intensive than a medical battle that we typically is our typical practice of what we are doing, trying to get people proven to be disabled, not trying to prove that they were, they've already been disabled, that's established, but now they're working too much. Some people call that a rich man's problem. It's not a rich man's problem because the person's disabled and doesn't have a lot of income. However, it's certainly a more well-off person than the person that's still fighting for their disability to begin with. And that's, of course, why we focus our efforts on the former, the disability medical battle, but also because the SSA has not made a system where they can readily pay, or they will. They just don't do it. They just typically, I see, disregarding allowing payment for overpayment. So most of us have a roof to keep over our heads, so we can't take those cases. I make the rare exception. No, it probably wouldn't be for you. No, nothing personal. It really runs by something different. And they're very few and far between. I mean, one a year, maybe one every 2 years. There are some people who are like, I'll do them. And I'm like, great, give me your name and address and I will send everyone to you because they do need it. But, those of us that don't have a silver spoon and are in the trenches doing the medical battles just can't throw the medical battle people under the bus to take the overpayment people. We have to get these people situated first because they're drowning anyway. But I do feel for the overpayment situation. If it is an actual non-overpayment. So if you're looking for an overpayment attorney, whether it would be me, rare, but if it's somebody else, this is what you're going to want to do. You don't want to just go to them and say, I got an overpayment, help me. No, get your ducks in a row. Show how it's not an overpayment. Do your due diligence. You are able to work, so you're not exactly completely incapable. So you have to show why it's not an overpayment. Do your research. There's a web page on what's SGA each year for the past gazillion years. So you can find out what was SGA each year that you are now somehow accused of not being. If you don't know what the SSA is asserting was SGA, then get all your income, your gross payments, forever since you've been working, so you can show. So whatever they're going to be pinpointing it as, if you don't know, although it should be in those letters at some point, you have the goods to show that you weren't. Get your IRWs if you have to. If it's a trial work period thing, which then affects your extended period of eligibility, which is where you're going to start getting overpayment months, get proof that you weren't working TWP. Although you probably were. I mean, that's the lower amount that people forget about. And you don't have to work under a TWP, but if you do, you're going to be jumping into your extended period of eligibility. We have videos on what those things mean if that's confusing to you. But if you are looking for an OP attorney, be prepared, number one, to pay a retainer, particularly if you are still collecting your benefits and there's nothing from which to get withheld fee from the SSA should the attorney prevail. And get your ducks in a row. Go month by month for every month you worked and know what you made, chart it out, use a spreadsheet or a piece of paper, a loose leaf piece of paper, but make it neat. Go month by month for every year, because that's what you're basically asking the person who's not getting paid to do for you. You could do that yourself. And if you do, and you could show, I bet you're going to have someone who will jump on board if you can come up with that retainer, because they're going to want to get paid too. They got mouths to feed as well. So anyway, just a word to the wise there at the end, but this SSA 795, awesome forum for completely objective information and also for documentary information that you can explain what it is and submit it. Okay. All right. Bye, guys. Ciao for now.